Email query coming in. Sunil Ransube says that he booked a 2 BHK flat with a renowned builder in Pune in 2014. He has paid 20% as booking amount and the builder promised an agreement within 6 months and a handover of the flat before December 2016. However, agreement has not yet been done in spite of several reminders. He has also sent a notice to the builder and now the builder wants to make an agreement with his terms, where there is no mention of the date of handover of the flat as well as no mention of the amenities promised, which was also there in the newspapers. Now, when Sunil asked the builder about this, he was told that the draft agreement is frozen and it can't be changed. There are over 700 other buyers who have signed the same, and if Sunil doesn't pay the remaining amount, then the builder will charge him 18% interest. If Sunil wants his money back, the builder will deduct 50,000 rupees and pay him back only after another person books the flat. What option is left for Sunil? You know, Uday, this sounds like one of those cases where the developer suddenly woken up and realized that property prices have gone up and I have sold my flat for a pittance, so let me try and get some more money out of the
Absolutely
buyer.
right, Kavita. It appears so that this is a total unfair trade practice, which is trying to do, by which is trying to, squeeze the either more money from the buyer or take him out by cancellation and sell it to somebody else. It is not correct. He can rush to the consumer court. There is a violation straight away for not registering the, if he is purchased the flat in Maharashtra, MOFA would apply. Section 4 says that even if single rupee is taken, he has to enter an agreement, and otherwise also he can't take more than 20%. But here the consumer forum will come to a great help to him, because agreement is a liability of the builder to enter after he pays the money, and there has to be an agreement. Normally these terms of agreement are fixed by various state laws. Now RERA also has fixed standard agreement format. So these standard agreements are to be followed, and the other clauses which are unilaterally arbitrary. Look at DLF case. Supreme Court has very heavily come on DLF, and crores of rupees are charged to DLF for unfair clauses in the agreement. So you can challenge even in Consumer Protection Act these unfair clauses of the agreement. There are several judgments of the National Commission. Most recent judgment was against, one of the question was against Lodha for making certain clauses which were against the MOFA. Similarly, there are against many builders, the judgments are there, but you must challenge these terms of agreement, insist on standard agreements which are very rarely fair, and the contractual obligations. Deducting money also seems to be unilaterally, unless it is a part of agreement which is agreed upon. 50,000 rupees deduction, that seems to be arbitrary unless otherwise provided in the agreement, and therefore it is better that he goes to consumer court and asks for his refund if the project is not getting ready, or if he wants to opt out after asking the possession to be completed in requisite time. Otherwise, it will become a monetary suit.
Now, you know, Uday,
Yes.
the problem here in
Yes.
Sunil's case is that he essentially doesn't have an agreement. He has paid 20% of the money.
True.
So what are the documents that he can actually showcase in the consumer court to build his case? Because over here, obviously, the first thing that he'll have to do before the court is to prove that he actually has some rights over that property in question.
Yes, because the day builder has issued him the receipt will say the flat number, the building in which he is going to get the flat, and it is sold for an house to be built by a builder.
Right.
And then builder becomes promoter, developer and service provider. Therefore, being a service provider, he should have entered an agreement. Is the first duty and obligation of the builder, which he has not done. There is a straight violation there. Then there is an unfair trade practice where the builder is asking extra money without any allotment letter or agreement or concluded contract, because the concluded contract then will go to the ready reckoner price of that time when he has booked it. The ready reckoner suppose is 2,000 rupees. Today he can't ask 5,000 and 6,000 rupees and balance payment. That would be a totally unfair trade practice. And there is a lot of wrongs done by the builder, for which a consumer can go to a consumer court for avoiding the unscrupulous exploitation by the builders, and that is the object of the act entirely. Therefore, it's a silver line to a common man, and therefore he, on the basis of receipts itself, he can prove that there was an agreement, that there was a contract between him and the builder. Builder is a service provider and he has defaulted by not entering an agreement. and thereby now it is an unfair trade practice to extract more money or making him go away or throw him away from his legitimate right of booking.
Right.
Because the rate can be found out from the ready reckoner at that time.
Right. So essentially it boils down to this. It boils down to the fact that as a home buyer, you need to know your rights. And one of the biggest things that you need to remember is that if you've even paid 1 rupee, like Uday said, if you've paid even
Yes.
1 rupee to the developer, you have every right to sign an agreement. You should demand, in fact, for an agreement. And if you do not get an agreement, that in itself should be a red flag, and you should either ask for your money back or take legal action at that stage itself.
True.
The other thing that you also need to remember is that once the developer has sold the flat to you, once you have signed an agreement, they cannot escalate the costs of that particular flat. It has been sold. If it has been sold at 5,000 rupees per square foot, that is what the developer is going to get. He cannot ask you for any more money after that. This is even though there is a cost escalation clauses which a lot of developers are putting in their agreements now. This, like Uday pointed out earlier, is an unfair trade practice, and you can go to court against it. And at the end, the other thing that home buyers need to remember is that you need to keep every scrap of paper that you get from the developer. You need to file it, whether it is a newspaper advertisement, whether it is a brochure, whether it is a receipt that you're signing. File it and keep it. It will stand you in good stead.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.